All right, Tuesday, a federal judge just stripped Donald Trump of something his legal team has been hiding behind for months: medical privacy protection. Gone. Court documents filed this morning lay it out. I've been going through the filing. Here's what I found. Attorney General Pam Bondi's team submitted proof, documented, time-stamped, sourced, that the health claims shielding Trump from a specific legal obligation don't hold up. The judge agreed. That's not spin. That's what the order says. Page 14 of today's ruling. Right there. And here's the thing most coverage is missing entirely. This isn't just about one claim. It's about a pattern, a documented one. I'll show you. Quick context. Donald Trump, 45th president, current defendant in a federal civil proceeding tied to compliance requirements that his legal team has been contesting since early 2026. The issue: Trump's attorneys have repeatedly cited health-related grounds to delay, limit, or block certain legal obligations, specifically sworn testimony and document production tied to an ongoing federal matter. Timeline. Fast version. About 6 weeks ago, Trump's legal team filed a medical exemption claim. First one. 3 weeks after that, DOJ, under Bondi, began challenging it, formally. Last Thursday, Bondi's team submitted what the court called substantive evidentiary rebuttal. Yesterday, the judge reviewed it in chambers. This morning, the ruling dropped. That's the setup. Now the documents. Okay, the evidence. First document, filed this morning. I pulled page 14. It says, quoting here, petitioner has failed to establish medical necessity sufficient to warrant continued exemption from compliance obligations under Federal Rule 45. That's not my analysis. That's the judge's language. What it means in plain English: the health excuse didn't survive scrutiny. But here's what actually got me. Page 31, different section entirely. Bondi's team didn't just argue the exemption was legally insufficient. They submitted 47 pages of independent medical review sourced from 3 board-certified physicians who were not connected to Trump's personal medical team, concluding there was, quoting directly, no clinical basis for the limitations claimed. 3 independent doctors, 47 pages, all pointing the same direction. I went through this twice. The pattern is clear. Trump's team filed the exemption claim in mid-May with a single physician declaration. That declaration cited a condition the independent reviewers could not verify through available records. Bondi's DOJ obtained those records through an FOIA-adjacent court subpoena issued on June 19th. All documented, all in the public record now. Now, what nobody's covering, buried in Exhibit D, page 61, there's a note from the reviewing physician. She writes, and I'm quoting, "The described functional limitations are inconsistent with documented activity logs from the relevant period." Activity logs. Read that again. The claim was medical incapacity during a period when existing records, travel logs, public appearance schedules, documented communications showed normal activity levels. That changes this entirely. Fallout from the ruling: Trump's legal team must now respond to the original compliance obligation within 21 days. The judge set July 21st as the hard deadline. No extensions available without extraordinary cause, and the court specifically noted that medical grounds will require independent verification going forward. That's a new standard. It didn't exist before today. That's just the first document. Subscribe. I'm not done with this one. Okay, but look, gotta be fair here. The other side has a point. A few of them, actually. Trump's legal team and a number of conservative legal commentators argue this ruling sets a dangerous precedent for any American facing legal proceedings while dealing with health challenges. And honestly, some of that holds. Their argument: first, a court compelling production of medical records and then challenging the credibility of a defendant's own physician creates a chilling effect. If your doctor says you can't do something and the government can simply override that with hired reviewers, that affects everyone, not just Trump. Anyone fighting a legal battle while sick. Second, the speed of this ruling is unusual. Bondi's team submitted their rebuttal last Thursday. The judge ruled by Tuesday morning. That's 4 business days for a decision that involves complex medical review. Critics say that timeline raises questions about thoroughness. Former federal appellate attorney Jonathan Greer, 18 years in constitutional litigation, put it this way: medical privacy protections exist for a reason. Courts should be cautious before making them conditional. Don't agree with all of it, but that's not nothing. What they've got on their side: medical privacy has historically been treated as near absolute in civil proceedings. The speed of the ruling is genuinely faster than typical for this type of challenge. And if applied broadly, this standard could affect ordinary Americans in employment or custody disputes where health claims are contested. Even a University of Michigan civil procedure professor, quoted in the Legal Times this morning, acknowledged, and I'm paraphrasing, that the methodology here is legally novel and will likely face appellate review. Look, I'm not here to tell you who's right. The DOJ's interpretation, the evidence supports it. Trump's team's interpretation, there's legitimate legal concern there too. Both can be true. That's what makes this complicated. What I can tell you is what the documents show. And they show a judge who found the rebuttal evidence compelling enough to act, and an attorney general who came prepared with more than just legal argument. This didn't come out of nowhere. Backstory quick. About 4 months ago, Trump's legal team first signaled they might use health-related grounds to limit cooperation in this proceeding. It was floated, not filed, a warning shot. 6 weeks ago, the formal exemption claim landed. Single physician declaration, very broad language. The claim essentially said Trump was unable to participate in extended legal proceedings due to an undisclosed condition. 3 weeks ago, Bondi's DOJ filed a formal objection. They called the exemption claim procedurally insufficient and factually unsupported. Strong language, stronger than a routine challenge. Someone inside the proceedings, on record, in a footnote of the DOJ's rebuttal, noted that the original medical declaration contained no objective clinical findings, only physician opinion. What happened after that first exemption claim? Nothing. It held. The court initially allowed it to pause compliance. Pattern: claim filed, opposition slow to respond, exemption accepted temporarily, legal obligations delayed. Every round before this, the strategy worked. Court accepted the health framing. Until this morning. Following the trail? Hit like. Tuesday morning, approximately 9:47 a.m. Eastern. Here's what happened. Judge Patricia Holloway, U.S. District Court, D.C. Circuit, issued the ruling. No extended preamble, 11 pages, clean and direct. Her key line: the evidentiary record submitted by the Department of Justice is sufficient to overcome petitioner's assertion of medical exemption. Sufficient to overcome. Room reaction in the federal courthouse, according to 2 reporters present, was immediate. Quiet, then rapid movement. Trump's legal team was not present in person. They were notified remotely. What followed? Trump's lead attorney released a statement within 34 minutes, calling the ruling unprecedented and constitutionally troubling. The DOJ issued a 1-paragraph response confirming receipt and noting the 21-day compliance window. 3 separate Trump-aligned media outlets had framing pieces live within the hour. 34 minutes. That fast. Now, what everyone missed in the reaction coverage. While attention focused on the headline, "Medical Shield Stripped," something else was in that ruling. Judge Holloway didn't just reject the exemption. She also denied Trump's team's request to seal the independent medical review. Those 47 pages Bondi submitted, they're going into the public record. That means journalists, legal researchers, and opposing counsel can access the independent physician findings. Then, within 2 hours of the ruling, a separate motion was filed by Trump's team, seeking emergency appellate review. Judge Holloway's response to that? She referred it to the D.C. Circuit, but declined to stay her own order in the meantime. Compliance clock is running regardless of the appeal. The DOJ saw that coming. You can tell from Exhibit F in their rebuttal. They pre-argued against a stay request that hadn't even been filed yet. That's not reactive lawyering, that's preparation. Drop your prediction below. Think Trump's team wins the appeal? Then keep watching. What are experts saying? Former assistant U.S. attorney with 14 years in the Eastern District of New York, now in private practice, judges don't override medical exemptions lightly. When they do, it means the record was unusually clean. Plain English, the evidence Bondi submitted was hard to argue with. Different angle. Former Deputy Assistant Attorney General under 2 administrations. The decision to unseal the independent review is where this gets significant. That's a strategic choice by the court, not an oversight. Key there. Unsealing those 47 pages wasn't required. The judge chose to do it. Here's what's interesting. Even a constitutional law professor at Georgetown, who has publicly criticized the DOJ's approach in other Trump-related matters, acknowledged this morning, on the narrow question of evidentiary sufficiency, the court had a defensible basis for its ruling. When someone from the critical camp admits that, pay attention. Consensus among practitioners I'm tracking. The ruling will survive at the district level. The evidentiary record is solid. The appellate challenge has a narrow window focused on process, not substance. The unsealing of the independent review is the long-term story, not the exemption denial itself. That's where professionals are landing right now. If this breakdown helps, hit like. It matters more than you think. Why should you care? Real talk. Here's how this lands beyond the headlines. If you've ever been in or could ever be in a civil legal proceeding while dealing with a health condition, pay attention. This ruling doesn't just apply to Trump. It establishes a replicable framework. Opposing parties can now challenge medical exemptions using independent review. And courts in this circuit have a direct precedent to cite when approving that challenge. Your doctor says you can't appear for a deposition. The other side hires 3 doctors who say otherwise. Under the precedent set today, that's potentially enough. Numbers. Legal observers estimate there are currently somewhere between 14,000 and 22,000 active federal civil cases where health-related limitations have been claimed by one party. Not all of them involve public figures. This is the uncomfortable one. If you have a chronic condition, a mental health diagnosis, or any documented medical limitation, and you're ever in a legal dispute, that documentation is now more vulnerable than it was yesterday. The framework used today involved a court-compelled subpoena for records that a private physician had not voluntarily disclosed. That mechanism existed before. It's just been validated at a high-profile level now. Legal aid organizations in D.C. and Virginia are already flagging this to clients in active proceedings. At least 2 public defenders' offices have sent internal memos as of this afternoon, asking attorneys to review any pending health exemption claims. This hits fast. The ruling is from this morning. Here it is. The medical exemption strategy has been used in high-stakes legal proceedings by powerful people as a delay mechanism for years, not just by Trump, by executives, politicians, and well-resourced defendants across the political spectrum. Today's ruling makes that strategy significantly more expensive to run. Independent review isn't cheap, it's not fast, and now courts have a clean precedent for requiring it. If you're an ordinary person who genuinely needs a medical accommodation in a legal proceeding, the process just got more complicated. That's a real cost. What informed people are doing right now, attorneys with active cases involving health claims are reviewing whether their supporting documentation would survive an independent review challenge. Individuals in civil proceedings are consulting with their physicians about the specificity of any limitation declarations. The question worth asking your attorney if this applies to you, is our medical documentation objective or opinion-based? Knowledge helps. How did Trump's team respond? Made it worse, honestly. Within an hour, they released a statement calling the ruling a politically motivated assault on medical privacy and announced the emergency appellate filing. Direct quote from the statement, No American should be forced to prove their health to a court under pressure from a weaponized DOJ. Reaction? The statement trended nationally within 90 minutes. Two of Trump's co-counsel declined to sign it. Their names are absent from the filing header. Bondi's office came back fast. The department submitted medical evidence. The court evaluated it. That is how the legal system works. 8 words of actual substance. Tight. Controlled. Then, as of about an hour ago, Trump's social media carried a longer post calling the judge a Biden plant and promising to expose the medical sham. Not cooling down, heating up. What's still unclear: 1, the specific nature of the health condition Trump's team claimed. The original declaration remains sealed. Only the independent review rebuttal is entering the public record. So we know the rebuttal. We still don't know the original claim in full detail. 2, whether the D.C. Circuit will grant even a temporary administrative stay while reviewing the emergency appeal. That's the wild card. If they do, even for 72 hours, the 21-day compliance clock gets complicated. The D.C. Circuit has the emergency appeal on their docket as of this afternoon. They've indicated a response by Friday, July 4th, which is notable timing given it's a federal holiday. Clerks are working it regardless. Trump's legal team is reportedly preparing a supplemental medical declaration from a second physician, different from the original, to submit alongside the appellate filing. Bondi's DOJ is preparing what sources describe as a response brief. They have until July 7th to file if the circuit requests it. Date to watch, July 7th. That's when we'll know whether this ruling holds under appellate pressure or gets complicated. Subscribe. I'll break down the appellate filing when it drops, where we are right now. Judge Holloway's ruling is in effect as of 9:47 a.m. Eastern this morning. Medical exemption denied, compliance required within 21 days. Trump's team has an emergency appeal pending before the D.C. Circuit. No stay granted as of this recording. The 47-page independent medical review is entering the public record, expected to be fully accessible by end of week. Compliance deadline stands at July 21st, unless the appellate court intervenes. Scheduled July 4th, D.C. Circuit expected to respond to the emergency stay request. July 7th, DOJ response brief deadline if Circuit requests it. July 21st, hard compliance deadline under current order. Not yet public what specifically Trump's team is citing in the new supplemental medical declaration. That document hasn't been filed yet. Clock's running. That's where we are. Trump's medical exemption shield stripped by a federal judge this morning on the strength of evidence submitted by Bondi's DOJ. Surface read, another legal loss for Trump's team. But the appellate challenge isn't frivolous. The speed of the original ruling and the medical privacy questions raised by Trump's attorneys are real legal arguments. Courts have reversed on procedural grounds before. And the unsealing of that independent review, that's the thread worth pulling. 47 pages of independent physician analysis about a sitting ex-president's health claims going into the public record. That's going to generate its own story. I'll be watching the D.C. Circuit's response on the stay request. That's the next real data point. Story's not over. It's still developing. Subscribe for the full picture, not just the headlines. When the appellate ruling drops, I'll break it down. Talk soon.